Recording the cloud. Cool. Well, another session, another day, and I'm really excited to be here with Joe Williamson and Carlos and the rest of the people from Eight Builders. And thank you to Jill for joining us. And she will be speaking about crypto and the law.
All right, so I guess that's my cue. I guess I'll just start with a what I like to call the nickel tour of agencies and applicable law. It's probably more like a 50-cent tour because there's a lot of agencies that regulate in this space, and so and a lot of laws. But I'll start with the SEC because that's the one most everyone is familiar with. Everybody's conversant more or less in the Howey test, and everyone is concerned about whether their token offering is a security. So I think, for anybody who's been in this space for more than a minute, they know that the SEC might have something to say about their activities. The next one is a little bit less obvious, and that's FinCEN, which is a department of the Department of Treasury. FinCEN is the Financial Crimes Enforcement Network. FinCEN's job is to enforce what's called the Bank Secrecy Act. And the Bank Secrecy Act is the anti-money laundering statute in the United States. So almost all anti-money laundering requirements stem out of the Bank Secrecy Act. And FinCEN regulates and enforces compliance with the Bank Secrecy Act primarily for those financial institutions that don't fall within other regimes. So for example, FinCEN doesn't regulate banks because banks are regulated by the OCC and a bunch of other regulators. FinCEN doesn't regulate securities brokers because securities brokers and their anti-money laundering requirements are regulated by the SEC. So FinCEN kind of regulates that catch-all category of institutions that don't fall anywhere else. FinCEN, with respect to crypto and blockchain, is primarily but not exclusively concerned with what's called money transmission or a money services business. But the way that the Bank Secrecy Act works is that if you are a quote unquote financial institution, then you are covered by the Bank Secrecy Act and you're required to have an anti-money laundering compliance program, which includes, having an AML officer, which includes having controls, KYC. It also includes mandatory reporting of, suspicious transactions over $10,000 and that sort of thing. There is a long list of types of activity that means that you fall within the definition of financial institution. So again, one of those is money transmission or money services business, but there are others: payment processors, check cashers. There's a lot of different types of activity that falls within that definition of financial institution. And then interestingly, like the very last clause in that definition section says, and any other thing that the secretary may decide. So, that the secretary hasn't decided that there's a new category of financial institution in a while. But the point is that the secretary could, Secretary Yellen could decide tomorrow that there was some new kind of financial transaction that presented a risk of money laundering and therefore should be included under the definition of financial institution and would be covered by the BSA. So that definition is fairly, I want to say it's fairly dynamic, but that's not exactly right. It more has the potential to be fairly dynamic. But it's important to recognize that it's not static, that, inventing a new kind of financial institution that isn't on that list isn't going to get you very far for very long. And then the last agency that has the most regulation applicable to particularly cryptocurrency, and the agency that's probably been the most quiet in this space to date, is the Commodity Futures Trading Commission, the CFTC. The CFTC regulates two things. They regulate futures and derivatives. So any futures and derivatives covered by the CFTC. And they regulate spot trades, but only insofar as concerns fraud and market manipulation. So as a general matter, spot trades of commodities are not regulated. You don't have to be a broker. You don't have to register with CFTC. There aren't any rules. It's spot trades. But fraud on the market, market manipulation, and spot trading, that can be a violation under CFTC regulation, or futures and derivatives. That brings you firmly within the CFTC's purview. So those are the three main agencies that regulate cryptocurrency. That's probably, the nickel tour. I don't know if within that nickel tour people have questions. Why don't you guys kind of tell me where you want to go from here? I can talk about like some key misunderstandings. I can field questions. We can talk about the panel this morning. I co-hosted with the DC Bar a panel discussion with the enforcement directors of the SEC, CFTC, and FinCEN, which is kind of a big deal. It's really unusual to get the enforcement directors from three agencies on a panel together. So, it was really useful to, even though they all basically said the same thing, they said it together on the same panel. So, that was, I think, useful. So, you guys tell me where you want me to go from here.
Excellent. So I have a question from Carlos. Can the compliance officer be the same person as a CEO, for example?
Sure. The BSA compliance officer, I mean, you can have a financial institution with just one employee. So absolutely, your BSA officer, your AML compliance officer can be the same person as the CEO, as long as that individual is qualified to carry out that activity, which means, they don't necessarily have to have a certification, although that's always helpful. But they have to be familiar, not just with the law, but also with compliance processes, which is a whole separate thing, like knowing how to build a compliance program, how to do a risk assessment, what, controls are a good match for the risks that you've identified in your risk assessment. All of those are, pretty specific processes. And so, yeah, as long as that person is qualified to do it, it can be the same person.
Excellent. So Peter Duhon asks, Elizabeth Warren asking SEC for regulations on crypto and wants to report by July 28th. Any thoughts on that? We'd love to hear about the panel from earlier today.
Yeah, I mean, honestly, I kind of teed that up with the panel. I asked them if they thought that there were any blank spots in the regulatory regime that kept them from enforcing activity that they really thought needed to be, subject to enforcement. And uniformly, they said they thought that the laws that they had really pretty much covered the landscape. As a general matter, I think that's true. There's been a lot of talk about central bank CBDCs, central bank denominated or central bank. I've lost the. But for CBDC, central bank crypto, stable coins, basically.
Yeah, central bank cryptos. New
money.
Yeah.
So there's been a lot of talk about that, but that's not really something that can be regulated, or legislated in the U.S., because each country is going to do its own legislation, because there's only one central bank, because it's, central. So there's only one central bank in each country, and to the extent that countries have them. So, the thing that I see, well, there's two things. One is, despite what the panel said this morning, I do think it's going to be tough to get at DeFi. I don't mean all DeFi, but I mean that DeFi that is clearly breaking US law. Not for the reasons that people commonly cite, like, who are you going to arrest? Nobody's doing it. It's happening by itself. Like, regulators aren't really convinced by that. Like somebody wrote the code, somebody's maintaining the code, somebody's getting paid. Like there's generally somebody somewhere that can be arrested, right? Um, so, the regulators aren't fully convinced by this whole autonomous network thing. But a lot of the actors are outside of the US, and I think that's probably, or they're unknown or they're difficult to discover. Um, I think those are probably, more compelling reasons that it's difficult to enforce against DeFi. And, the other issue is that generally, the laws regulating this stuff don't apply to investors, right? They're there to protect investors. So while it may be unlawful to host a platform that, to trade derivatives, it's not necessarily unlawful to invest in that platform, because that law was designed to protect the investor, right? So it's not designed to prosecute the investor. Again, this is a generalization, so don't take this to the bank. There are exceptions, but the fundamental framework of the law doesn't prosecute investors; it protects them. And but the investors are the people that are easiest to get at. So that's one way that you could change the legal framework slightly to make it easier to get at DeFi. But it's a huge shift. I mean, it would be a historic shift, because these regulations have never targeted investors. The SEC, like all of those regulations, SEC, I mean, FinCEN's and anti-money laundering, so that doesn't really have anything to do with investors. But SEC and CFTC, their whole raison d'etre is to protect investors and protect the integrity of the marketplace. So to go after investors, like I said, would be a seismic shift in how regulation works in the U.S. But to my mind, it's probably one of the few ways that you could effectively get at DeFi right now. Even putting aside the theory that DeFi isn't run by anybody, and therefore who would you arrest? The other thing that I think could come down the pike, and we've seen hints of it last year, is some stablecoin, some definitional regulation. So what is a stablecoin? You could see some definitional regulation that says a stablecoin is a fiat pegged cryptocurrency that's fully reserved, and the reserve is held in an FDIC or similar account. Because not because they want to shut down stablecoins, but because that is very low risk. That presents, very low risk to investors and very low risk to the marketplace. And so by defining that, you could carve it out and make it clear, what that is. And the regulators this morning did make some mention of the fact that, the nomenclature in this space is meaningless. There is no agreed upon lexicon. So what I call a stable coin is completely different than what somebody else calls a stable coin. They're not all the same. NFT is another good example. There could be some definitional work around NFT. Again, as a way to carve out those things that are low risk and not subject to financial regulation. But you need a definition of that in order to carve it out. So, I think probably stable coins and perhaps NFTs, we'll see a lot of legislation. We saw it last year, but there's a difference between, legislation being introduced and legislators being serious about actually passing legislation. So you'll see a lot of stuff introduced for a lot of reasons, but you'll be able to look at the sponsors. You'll be able to look at which committees it goes before. You'll be able to look at whether it's taken up by the committee. All of those are going to be signals that people are actually serious about this legislation, and they're not just doing it for a press release. Elizabeth Warren, that her name has some gravitas. If she actually co-sponsors something, she means it. So, we'll have to see.
Excellent. I'll ask a question. Where do you see regulations around wallets specifically?
I mean, FinCEN put out some pretty good guidance around wallets. I mean, what's your specific question? I mean, there could be a lot of, like, wallets do a lot of stuff, and
Exactly. Yeah. So like, I guess, are there any sort of regulatory risks that wallet providers like MetaMask or Argent Wallet or Rainbow could face, especially if they facilitate certain types of activities?
so yeah, so FinCEN put out some pretty good guidance on wallets. And if you're not familiar with that, the crux of it is that a genuinely unhosted wallet, that means a wallet where the wallet provider cannot independently control the the crypto in the wallet. So a multi-sig wallet can still be unhosted, um, but depending, again, you know, function over form. But a genuinely unhosted wallet, non-custodial wallet, thanks, Peter, um, that is, fully controlled by the user, and therefore any transactions that come from that wallet are not money transmission on behalf of the wallet provider, because it's basically a peer-to-peer transaction. So money transmission is when you facilitate the transmission of funds from one person or location to another. So if I walk up to you, Anthony, and hand you $5, there's no one facilitating that transaction, right? There's point A and point B, but there's nothing in between. So a non-custodial wallet, any of those transactions, they're peer-to-peer. The wallet provider is not in the middle of that, and is not responsible. I think it's too simplistic to think, though, that then that wallet provider may not be conducting money transmission through some other services associated with the wallet.
Oh,
So
there's the detail. We'll double in the
yeah,
detail.
I mean, because the money transmission question has to go to each aspect in each transaction. So just because they're not a money transmitter because they provide the wallet doesn't mean that they're not a money transmitter if they facilitate other transactions to and from that wallet. Um, so it's a little difficult to say on the whole. Um, but so far wallets are being treated like open source code. Um, I don't know. I mean, there's so much going on that my imagination fails me. Um, but I can't think of anything offhand that seems like you know the current regulations wouldn't cover it. Um, but people have new ideas every day. So I'm sure some client will come to me tomorrow and I say, I can't think of a reason that's illegal, but I could think of 5 reasons that it maybe should be.
That's funny. That's interesting. It's very interesting to hear you say that the current regulations can kind of cover a lot of the aspects that are happening in DeFi. That's actually pretty refreshing in some ways.
I've been saying it for a while, and it was refreshing to hear regulators. And I think maybe hopefully Carlos will agree. I feel like any clients of mine will have heard words from the panel this morning that sound just like stuff I've been saying for the past 4 years. Like, it doesn't matter what you call it, it matters what it does. And it doesn't matter that it's a new technology or that it's doing something in a way that's never been done before. It matters what you're doing. So, and that's why I think it's tempting to say the laws don't address this because it's never been done before. But that's not really how the laws work. That the laws get to sort of what's the purpose of the transaction, what's actually happening, not what the technology is that's facilitating that. So
This time is different. Does not necessarily apply, perhaps.
yeah, I mean, it might be super innovative and it might be groundbreaking technology, but it could still be money transmission, or it could still be a security.
Now, when you mean money, do you mean money in terms of a stable coin, or could it be like, let's say, uh, some sort of random asset that has a utility? So what is
Yeah,
money
so
is value?
the Bank Secrecy Act applies to money and anything that acts like money. So what's often called cash or cash equivalents. So if you use it like money, it can be subject to the BSA. And that's why, the panelists this morning were a little bit cagey. I dropped a question, you know, for Petal about NFTs, and he's like, oh, depends on how you're using it. Just because it's an NFT doesn't mean it can't be used like money. And if it's used like money, it's subject to the BSA.
So is there a type of value that is still valuable, but not used like money?
Oh yeah, but mostly those are securities.
There you go. So still covered. Okay. That's good.
But not entirely. I think NFTs are a good example. I mean, NFTs obviously have value. But in their most traditional sense, an NFT is just a collectible or proof of ownership. And we deal in those every day. We know that they're not regulated. We know they're not securities, and we know that they're not subject to the Bank Secrecy Act. And to the point that these laws are technology agnostic, the fact that it's happening on the blockchain doesn't change that. So to the extent that you're selling something that's purely a collectible that has value, that's not fungible, not to state the obvious, then it's not money transmission. It's not subject to the Bank Secrecy Act. Presumably there's a point at which, I know that, some of these NFTs, that there's not just one, right? Like NBA Top Shots will sell 1,000 of a single Top Shot. So there is a point at which presumably these do become commodities, and they could be like a cryptocurrency. I don't think anybody knows where that point is yet. But yeah, I mean, if you issue 1 million identical NFTs, I think you're going to be hard pressed to convince somebody that that's not a cryptocurrency, and it can't be, that it's not intended to be used like money. But so far those waters haven't really been tested. I couldn't tell you where that line is, but there's got to be one somewhere. Adding some video or rights to some video to a cryptocurrency is not going to really keep you from being treated like a cryptocurrency.
Interesting. Yeah, programmers and developers will get very creative in the ways they do things.
Oh, I know. Like I hear it's like, well, what if I add a video to it? Then it's an NFT. I was like, really not.
Yeah, are there a million of them?
Yeah, I mean, are you telling me that you've got a cryptocurrency project that now you think you can avoid regulation by adding, some digital rights? Then I'm going to say that doesn't just instantly convert it from a crypto project to an unregulated NFT project.
What if you can redeem them for socks? Would that change the game?
I mean, then that's starting to sound a lot like a derivative or or a share, right?
Yeah.
It sounds like an indicia of ownership of a convertible note. There's a lot of things that it could be like, but most of those are regulated.
Oh, that's interesting. That's very interesting. All right, questions from the crew. I guess JC asked, what about a transaction done to exchange tokens on a DEX/DeFi, on a decentralized exchange? Do the 3 regulators consider this the same as a spot transaction?
Sorry, I didn't hear you very well at the end there.
Oh, sorry. So what about transactions done at decentralized exchanges? Do the top 3 regulators consider this the same as a spot transaction?
So I guess I can add, like, based on what you just said, it sounds like especially the SEC and CFTC are mainly interested in protecting the investor and markets, which is what you said. And so I would expect that we should expect regs on decentralized exchanges such as Uniswap, Compound, etc., that are creating markets to sell to the investor. So anyone that comes up with a protocol, and obviously we have like tons of protocols that come up to basically and offer a decentralized exchange service, so like an exchange of a token, etc. So I would expect that the regulators would be effectively expecting them to comply to similar laws as they do expect existing financial institutions to do so. But I just wanted to see where our head is at on that.
Yeah, I mean, I think they've made it clear that they, calling it a DEX doesn't mean that you're not, that it is necessarily a DEX. I mean, peer-to-peer transactions, again, if I were to walk over to my neighbor's house and hand him a certificate of stock that I have, that's not regulated, right? But and providing a forum for peer-to-peer transactions, securities, I'm not sure where that line is drawn. FinCEN's drawn the line to say if you provide matching, that's not money transmission as long as the settlement occurs either through a regulated financial institution or on a peer-to-peer basis. Uniswap is interesting, and to be honest, I don't fully understand the legal theory. Like they are a US company, and they're large enough and notorious enough that I would have expected a cease and desist if what they were doing was clearly unlawful. But I haven't seen behind the curtain to see sort of all the legal theories. Honestly, I don't know how their code works, right? Like how do they earn their money? How hands-off are they? How much of this is actually peer-to-peer? That's where those answers are. And I don't have them with respect to Uniswap. I want them. I would love to sit down with Uniswap's legal counsel and say, walk me through, how this works in your head. Because I think it would be very illuminating. And honestly, a lot of what we do, those of us who practice in this space, is we do kind of try to reverse engineer and say, is this a path? A lot of times it's not. I've got clients that say, well, so-and-so is doing it. And I look at it and it's like, it's illegal. There's no path here. And sometimes I look at something and I was like, oh, that's brilliant. There is a path. I see it. So with Uniswap, I see a few potential paths. I just don't know what their actual path is.
So you're saying that smart contract developers need to team up with lawyers in the future?
Yeah, absolutely.
Yeah.
I mean, if they said it this morning really clearly, like if you are undertaking a project that involves some sort of financial transaction, there's a high likelihood that it's regulated and you need to sort that out. You either need to call them for their advice or, get independent counsel or both. But any kind of a platform or process or transaction that is financial, it's probably regulated.
Awesome. Good. Great to hear. So Danny.
Well, I mean, it's not great to hear, right? Like, for business.
Not at all. Not at all, but at least there's some clarity. I mean, whether it's good or bad,
Yeah.
up in the air at the moment. Daniel, if you want to ask your question, or I can ask the question for you. Daniel M has a question.
Oh yeah, so I have a question. So I feel like most of the so far DeFi projects, like most of them, they don't do KYC or AML check compliance. So one is like, when do you think the regulator will start to check, because they haven't touched upon it? And if so, if most of them are not checking right now, so how are they gonna approach to check all of it? Because it's almost all projects. So will it be like, oh, starting from this date, we're gonna do it, so you better comply or something like that? Or like, I'm just curious how will they?
Yeah, no, that's an excellent question. Because I do think that people take a false sense of security from activity that, where the people haven't been thrown in jail. And so you think, well, so it's good. So, in my experience, and I've been doing, I mean, obviously not crypto work, but corporate compliance work, in the financial space for, God, over 20 years now. So, in my experience, the way that this sort of enforcement road happens is when when the agency discovers either that there's something new happening or that there's something happening that they think actually is subject to regulation, but everybody kind of thought it wasn't. The first thing they do is that they start making public statements. They'll, maybe make a statement on a panel, or they'll make some public statements that just say, hey, we're looking at this thing, or this is going on. Then they'll issue guidance. Then they'll do kind of an educational tour behind that guidance to give everybody a chance to digest the guidance and come into compliance. Then they'll start prosecuting. They usually try either prosecute low-hanging fruit or the worst offenders. And then it's everybody. And so, and we've seen that play out both with the SEC and with FinCEN, right? Like first they issued the Dow report and they said, and before the Dow report, they, there were some statements about ICOs and this and that. And then they issued the Dow report and they said, hey, here's how we see this. Get yourself right. And then, they issued some more specific guidance. The SEC maybe less than they should have, but they issued some guidance. Honestly, the Dow report was pretty specific with respect to, what one could consider guidance. Then they did a lot of speaking. They went to a lot of conferences. Like they really sort of rattled the chains and said, look, we're coming. If you're not aware of this, you need to get aware, and you need to read the Dow report, and you need to get straight. And then they started prosecuting. And they're still prosecuting, and they've been kind of gentle. Although, Ripple maybe wouldn't say that. But they've been kind of gentle. The other thing that you don't see is there have been a lot of non-prosecution agreements behind the scenes. So, it's again, especially early on, if a company either comes forward and says, ooh, we think we may have tricked here, or if maybe the SEC sends an inquiry letter and says, can you explain, we noticed that you did this token offering. Can you explain that to us? We have some specific questions. And, and that's a great time to go to the SEC and say, oh, crap. We got your letter and we looked at this and we may have actually broken the law. How do we make it right? So, if a company comes really aggressively and says, look, yeah, we may have broken the law, but we're going to make it right. Sometimes, often you can get what's called a non-prosecution agreement, and that's not public. So when those happen, you don't know that they've happened, and these aren't public companies, so they don't have to report it like a public company would. They don't have to make a public disclosure. And the non-prosecution agreement will say, everybody agrees to these facts. Everybody agrees that these facts are a violation of the law. And the company makes these undertakings. And as long as the company follows up and does what they say they're going to do, there won't be any prosecution. But again, those aren't public. And, I'm aware of a number, and I suspect many more non-prosecution agreements have occurred in the background, which makes it seem like there hasn't been enough enforcement. But in fact, the SEC just gave these companies time to get right, and come into compliance and fix the mistake. The same is true of FinCEN. There's been a number of settlements, non-public settlements, a couple that I'm aware of, and again, a couple that I suspect strongly. So clues that a company is under investigation and trying to get a non-prosecution or a deferred prosecution agreement. You will suddenly see that they're hiring like 10 people in their legal department, right? That they're suddenly advertising for a chief compliance officer, a compliance manager, a chief legal officer. Like suddenly there's a spate of openings in compliance and legal where there were none before. That's either a sign that they're thinking of doing an IPO, or a sign that they're in a lot of trouble and they're trying to dig themselves out. So those are my sort of indicia of a company that either has just completed an NPA or is close to signing an NPA. But that's just, it's mostly speculation, because unless you're representing one of those companies, which I have represented some, and I've represented other companies in other spaces, like, healthcare fraud or, anti-bribery, anti-corruption spaces where that's how it played out. So I forgot the question.
Awesome. Awesome.
Something enforcement, something dexes, something, how's that going to play out? So, I think the CFTC is a little behind. Their guidance, their public statements, they haven't made a big splash yet, and there's only been a handful of enforcements. But I think FinCEN and SEC, they're pretty far through this cycle. Like they're gonna just start enforcing. Like it's been 4 years now. They've given the notices. They've issued the guidance. They've prosecuted some big cases. They expect everybody to know this, and they're gonna, I think, step up the prosecutions if the industry doesn't take the hint.
So you're saying that they make exemplary actions in a sort of granular but more ratchet up way every time to sort of say, hey.
Well, kind of, right? They have limited resources, to be fair. So, what their hope is, honestly, is that if they enforce and if they signal in the right way and then they enforce in the right way, then most of the companies will come into compliance. And then that just leaves a small handful of companies that they need to enforce against. We're honestly a long way away from that. And so, again, they have limited resources. So they're still going to prioritize either the biggest projects or the most dangerous projects, because they just can't, everybody knows, dozens of projects that probably are breaking the law. They can't. They don't have the resources to go after everybody. So, yeah, I think they still are going to have to pick their targets, and they're going to pick their targets based on, who's the most dangerous or who's the easiest to get at.
So completely unrelated, what are your thoughts on Tether?
Tether?
Yeah, like with the Tether and the overall take on security regulations on stablecoins. George Harvey asked this. Hervey. Yeah.
There's no requirement that a stablecoin be fully backed, right? Because we have no definition of a stablecoin. So a stablecoin is basically a contract between you and whoever purchases it. There are a lot of questions about whether Tether's representations are fraudulent. I think that there probably are legitimate questions about this, that if they are fraudulent, is it some also market manipulation or fraud on the market? But, obviously, I mean, the interesting thing about Tether, of course, is that as long as the token stays stable, investors aren't really harmed. And so while it's huge and while it may be fraudulent, it may not be dangerous. So if I had to guess why they're not in trouble, it would be because nobody's losing money on Tether.
So the shoe hasn't dropped. Everything's good.
I mean, that even when the rumors were bad, it didn't break its peg for very long. And as long as it stays on peg, nobody's really losing money.
That's interesting. Great. Awesome. So, okay. So Hassan has a question. I'm working on a project that uses an NFT to represent an options contract. What sort of legal waters do I need to navigate?
Well, the options contract is regulated by CFTC. So, if you think of, obviously I don't know the details, but if you think of the NFT as just being the indicia of ownership or the representation of that contract, then that contract would need to follow whatever applicable laws under the CFTC. To be fair, I am not the commodities regulations, options, swaps, derivatives is probably my least conversant. So, you know, beyond telling you that an options contract is regulated by the CFTC, I probably couldn't tell you how. I mean, I couldn't tell you like what the rules are with respect to option contracts. That's my, it's definitely not my sweet spot. But tokenizing an options contract won't take it outside of CFTC regulation.
Nope. So magical internet technology doesn't change.
No, digitizing it doesn't change it. And sometimes I tell clients, you know, look, if you did it on paper, would it be legal? Because moving it to the blockchain doesn't change that.
It creates a long-term record, right? Have you
Well,
heard
right.
prosecution futures? I heard that somewhere a long time ago, and it's like, oh yeah, this is awesome. It's a great term. Kwame, you have a question?
Yeah, thank you for the presentation. It's really informative. I just wanted to ask if there are teams that are implementing DeFi projects or protocols, what guidance would you give them if they're just starting out and haven't gotten themselves in a mess yet?
Get a lawyer. You know, I think this is definitely a space where it's better to get legal counsel sooner before you've invested a ton of time into a project that you discover is subject to regulation. You know, regulation is not the death knell, but it does change your timeline for rolling it out. It changes your expenses. You know, so, you know, if you're entering into a regulated space, you can make informed decisions. Again, it's not necessarily the death knell of a project, but it does change a lot of the assumptions about how you're going to go to market. And so I think it's better to know that sooner rather than later. You know, so that's probably, you know, you can move without a lawyer. You know, you can call, you know, if you're doing a DeFi protocol, I probably would call FinCEN, and they might tell you also to call CFTC or SEC, depending on how the protocol works and what it's doing. But you know, you can call them. You don't even have to tell them who you are. You know, so you can call them on a no names basis and try to get an early steer on, you know, whether you're headed into heavily regulated waters. But yeah, I think it's better to know that sooner rather than later.
Great, thank
Hey,
you.
I just had a quick question. When it comes to NFTs, any thoughts on how NFTs might be looked at in the eyes of maybe like in terms of copyright and but just in general, have you heard about maybe how, you know, the law may view NFTs for the most part?
Yeah, so that is interesting because NFTs do bring in a whole new sector of law, you know, all of the IP, copyright, trademark, that we haven't talked about yet. You know, honestly, again, making it digital, I don't think it really changes anything. You know, the terms and conditions are going to outline, you know, what it is that's being sold and what the rights are associated with that. I think if you go to NBA Top Shot, you know, you look at their terms and conditions, you know, it makes that pretty clear, like you're getting this right and not that right. You know, you can do this with it and not that with it. You know, you certainly, you know, if you were to try to sell an NFT that had copyrighted properties that you didn't have the rights to, it would be the same as if you were, you know, doing that, you know, on YouTube, you know, or, you know, in a book. So, you know, in many ways, I think the real, to me, the real fascinating piece of NFTs is the capacity for the creator to earn royalties on subsequent sales. You know, because our current marketplace, our current construct, you know, creators really get hosed, right? Like they sell something in the first instance, and as it appreciates in value, in large part through their efforts, right? As their work gets more known, as they create more works, they don't get the value of the appreciation of those initial works, even though they contribute to that increase in value significantly. Again, as their body of work grows. And so you know, I'm quite bullish on NFTs, both because I think if used properly, they're a nice unregulated space. You know, if they're, you know, if it's a genuine NFT, not intended to be, you know, used as a, you know, that's not fractional ownership, that's not intended to be used as a substitute for money. You know, it's a pretty straightforward space from a regulatory standpoint. And it's also very familiar. I think NFTs could be the gateway to mass adoption for digital currency, because collectibles are familiar. People understand buying something just to say that they own it. And once you get people hooked on NFTs, then it's a short step to cryptocurrency. And you know, so like I said, I'm quite bullish on NFTs, and I don't think they really changed the law. I do have some clients, you know, I have done a little bit of NFT work, and of course it's increasing as that explodes. And I think my sort of two legal tips that I have for clients is, one is, you know, it's not entirely clear that any existing agreements that you have might cover an NFT issuance. So to the extent that you can amend those agreements to include NFTs, you know, that's the safest course. The other thing is, you know, in the contracts that I draft, I don't draft them just for NFTs, because as we know, you know, the names change, right? Like something that looks like an NFT and is called an NFT today is going to be called something completely different in 6 months, but it's going to be mostly an NFT with a different name. So I tend to draft licensing around NFTs in much broader terms. You know, in any digital representation created on the blockchain or similar technology, you know, you know, just to allow for that growth and that evolution, and to allow for the fact that names are kind of meaningless right now because there is no strict definition of anything.
Just to follow up real quick with just one last question about that, what you just said. What are your thoughts on you know, with NFTs, should an NFT seller and an NFT buyer be careful if there's a chance that the other person that they're doing the transaction with is in another country? Not specifically because just because of maybe like jurisdiction, international law rules. Should you only really look to do business with your NFT for those people within the United States?
Kind of depends on how much you're paying for it. You know, if it's a big transaction, then honestly, you should get some legal opinions. You should get some reps and warranties. You might do some due diligence. You know, just as you would with any major transaction. I mean, people acquire rights to intellectual property across borders all the time, but if they're spending real money on it, then, you know, they do due diligence. And like I said, they get reps and warranties and legal opinions, and, you know, they spend some money to make sure that what they're buying is worth what they think it's worth and can be used in the way that they think it could be used. If you're not spending real money, then it's, you know, it's a gamble, but, you know, you're not spending real money. So, you know, and it's, I can't tell you what real money is. It's going to depend on you, right? But certainly, if you're investing a sum of money that you can't afford to lose, then I would also either invest in the legal work to make sure that it's worth what you think it's worth, or walk away from the deal.
Excellent. So I have a question from Phil. Phil, do you want us to ask the question or I'll ask it for you? Phil Kelly. Going once. Okay, I'll ask it for Phil.
Yes.
Oh,
Great.
there you go.
Hi.
Okay.
Hitting on detail.
Yeah, I was going to ask, can you comment on how some governance tokens, I mean, obviously the well-known ones like Arving Compound and liquidity tokens are escaping being characterized as securities in the US, and whether they're going to be able to maintain that status? I mean, the fact that they're listed on the public exchanges means, I guess, that everybody has a high degree of confidence that they are outside the net. But I was wondering what the rationale was against the Howey test.
I have to admit, I'm not familiar with the specific examples that you cite, but I would say that if they meet the Howey test, if they meet the definition of security, the SEC is going to treat them like securities, regardless of whether they're issued by a government. So if they represent an investment of money with an expectation of profit through the efforts of others, then which governments issue things that are deemed, they issue bonds, they issue T-bills. So governments issue things that are securities or investment contracts all the time.
Yeah, Jill, by the way, sorry, that was governance, not government. I mumbled that.
Oh, governance.
Yeah, yeah, sorry.
Yeah, so governance tokens, again, a thing that people call a thing and think that it means something, and the regulators don't care what you call it. So, I was just kind of stuck into this today. Under the Howey test, if an investor has primary or substantive or full control over their investment, it's not a security. But if the control they have over their investment is minor, then it can still be a security. So if governance tokens, if you pay money for them, if they're expected to increase in value or generate some other kind of income, unless the holders of those tokens have really substantial control over the common enterprise, they're still going to be securities. I mean, conceptually, there is a path where like a co-op type path where holders of governance tokens have enough control over the common enterprise that those tokens are not securities. But it's going to be fact and circumstances dependent.
Yeah.
Follow up with that. Would the distribution of the tokens, say a small percentage of the tokens are controlled by some investment fund, would that change the distribution? Like, does distribution matter in the Howey test? Say if 1% of people own 90% of the tokens, and then the rest is like across different people.
I don't think that matters. I mean, unless it affects something else, but just by itself, I don't think that changes anything. The thing that it changes, of course, is that potentially that 1% are, for example, accredited investors, and therefore they fall into a registration exemption. They fall under Rule D or Reg D. And that can be a saving grace, of course. And so then it's only your 1% that you may have an unregistered securities offering problem. Yeah, distribution shouldn't matter. If you sell it, if it's an investment of money with an expectation of profit in a common enterprise with an expectation of profit primarily through the efforts of others, then they'll say it's a security.
So what if it's like, I guess how we define a co-op, let's say it's a governance token, but the only way that you maintain the share of your token is by continually adding to the governance process through votes, right? Like participation. Like, all right, you have tokens, but if not, you're gonna get inflated away if you don't participate. Would that count as security in some way?
I mean, the thing that I remind people who talk to me, come to me with a governance token that they think certainly is not a security, is to remember that shareholders have voting rights. And, everybody knows that shares are securities. So, every shareholder has voting rights, but they don't have substantial control over the company in which they own shares. So having some participation rights is not saving. It won't save you from being a security. So does that help answer your question?
Yeah. I guess what would be the line of like minor
What would be
participation
the
and major participation, right?
I would have to, yeah, I mean, that's like a pretty deep legal analysis. There's a lot of cases talking about where the line is. But, part of me feels like the more governance tokens you issue, the less likely it is that you're going to sell the SEC that they have substantial control, right? Because how can 1,000 people have substantial control over their investment in a common enterprise? Because each of those investors is separate. It's a separate analysis, right? So it's not that the 1,000 people collectively control it. It's, does any individual investor have substantial control over their investment? And when you've diluted it 1,000 times, it seems impractical to make that argument.
So that's interesting. So I guess that it's how you divide the work up, right? It's like, well, this person with this governance token is adding extra marketing effort or extra writing effort. So, if the person wasn't here, then we wouldn't be able to do this. So it seems like a very nuanced thing, right? Like, what is substantial?
It's pretty nuanced. I mean, there are no, I know, a lot of the frustration with the community is that there are no bright lines, right? They're not going to say 10 governance tokens is okay and 20 is not. They're going to say, yeah, it depends.
Awesome. Excellent. So Alp has a question. Alp, do you want to ask the question or I'll ask it for you?
Yeah, sure. Hi, Jill. You mentioned that smart contract developers and lawyers will be working more in the future. Do you think for every instance to work with a lawyer, instead the lawyers or a government entity publish a framework for you to include in your smart contract? Instead of smart contract developers learn law, what do you think about lawyers learn about smart contracts and what it can be done with smart contracts and how to do you know Clerky that helps startups to fill the legal paperwork with AI? It's kind of like that, like a service that you can use or subscribe to that gives you the legal framework for a monthly fee, or like if a government entity publishes it, if you include it, you can put this is secured or this includes this government's framework. And by the way, the lawyers or the government can also update the code to otherwise in every instance, in every law change, you have to contact the lawyers. So it's not efficient from what I think. And I got the idea when you were talking and just quickly search on internet, and I saw there is I don't know if that's the solution, but there is a site called Open Law. I don't know, just saw it. So what
no, there are a lot of services that help people sort of DIY lawyering, right? And it's I'm firmly in favor of giving people tools. I'm not one of these people that thinks that lawyers can be the only smart people in a room. I actually, I'll give you a little anecdote. So before I went to law school, I worked in San Antonio, and I worked for an independent oil and gas company. And the president of that company, when he founded it, they had no money. He didn't take a salary for like a year. And so he had learned about Reg S, or Rule 144 private placements. And he found a consortium in Switzerland that wanted to invest in his company. And he flew to Switzerland, he negotiated the deal, he had it all set up. And then he hired a big oil and gas law firm to paper the deal. And they just assumed that, some petroleum engineer could not understand the regulation, and they tried to retrade the deal for him. And he's like, no, I read the regulation. I understand the regulation. This is the deal. And, he told me that story one time before I went to law school, and it has always stayed with me that, before I went to law school, I was not a lawyer. I didn't learn to read in law school, right? I learned a lot of things. I think there's a lot of things that I do that are specialist work that people don't have the experience, they don't have the knowledge, fair enough, but people can read. And so I think there is a level of tools and services that would be useful for people to DIY their work. I think where that's particularly useful is when the work that's being done is not nuanced. Well, two places. One is where the work that's being done is not particularly nuanced because, what I find often with clients is that they don't actually know what their question is. Like they don't know the space well enough to even know what the question is. So, I've had clients come to me and say, is this a security? I was like, no, it's not, but you're a money transmitter, right? They didn't even know to ask. So, I think, tools for things that aren't nuanced are useful and a good idea. And I think, sort of questionnaire kind of risk tools that can help people understand if they have a nuanced question that needs a lawyer. I think that could be helpful. So, if you had a series of questionnaires that went through like, are you doing this? And are you doing that? And, then it could say, hey, you might be a money transmitter. Maybe you should talk to a lawyer. Or, hey, this might be a security. Maybe, I think those kinds of tools would also be helpful to help people identify if they might be treading into dangerous waters. Honestly, we've talked a lot at my firm about trying to develop those tools, and it's just a time issue. It's a time and resource issue. It's really resource intensive, and we've got client work. It's hard to take time off the client work to devote the resources to develop that kind of stuff.
Yeah, but by the way, like instead of preparing a questionnaire, that there are testing frameworks in programming world that once you write your code, you just use the testing framework and see if there are some security issues, some other issues around the code, and there might be a legal framework that says like, no, you can't do that, or no, you can do this. Because why I'm asking the question, if something is ambiguous, lawyers tend to say no, because like if it's a gray zone, they don't want to danger their client, also themselves, so they say basically no, it's a gray area, don't do this, we don't know what will happen. But if there is a strict framework, then you know all the answers that you can do or you cannot do. So that was my question, actually.
Yeah, and you raise an interesting question, and to me that goes to lawyer selection. Because some lawyers will say no, and some lawyers will say it's gray and here's the risk, you decide. And so I do think it's important when you choose a lawyer to choose a lawyer that meets your needs in that respect. I also will say in my experience, and I used to work at big law, the bigger the firm, the less likely the lawyer is to want to take risks. Because it just systematically it's difficult, to do that. But but yeah, I think it's definitely an issue. But I think it's also primarily a lawyer selection issue. You know, I'm never going to tell a client that it's okay to do something that's illegal, but I don't run their business. So, you know, it's my job to give them my assessment of the law and where the risks are. It's their job to take decisions.
Thank you.
That's great question. If you have that idea or anybody has that idea, extending opening
Yeah,
up.
I love the sound of it. I have to admit, you know, to opine on the viability of it would require, you know, a technical expertise that I just don't have.
Sounds like a great startup if a developer.
I think the last time I coded anything was like in 6th grade when we were coding BASIC into TR-80s. So,
Hey,
Close enough.
Let
Close enough. The bar seems pretty slow.
me make a quick comment.
Yeah, Jay.
Sure.
Hey, Anthony, it's Jay, just checking in. Yeah, just if I think I followed the conversation, the question was, if you enter certain characteristics, could it tell you if you could you have like a program or a flow chart that tells you if you need a lawyer? And I think that the technology is evolving and that may affect the legal analysis. So it seems like you would need collaboration between a technical team and a law firm to kind of juggle this thing, keeping it accurate going forward. So that's just like an offhand observation. Then I did have a question. I know that there's, I think it's called rareables, where people will buy a share of like a, you know, like a Birkin, you know, handbag or something, and they'll split, you know, it's a $60,000 item and they'll split it into 30 units or something, and they do register that as a security, I guess. I guess that's kind of the question I had. Does that constitute control over the item itself that makes it a security?
It depends on how the contract works. You know, there's a really interesting collection of cases. Well, interesting to me, probably not interesting to many other people. But there's a lot of cases around the late 70s and early 80s around rental pools, where, and you know, it's fresh in my mind because I was looking at it this morning because I was looking at this issue for a client. But you know, the basic situation is, you know, you're a Florida condo developer, and you're selling condos to people who don't ever want to live in them. They just want them to be income properties, right? They just want them to appreciate. And so they sell the condo at the same time that they sell like a management contract. And so, you know, a purchase and sale of a condo, that's not a security, right? I own the asset. I have full control over the asset. But when bundled together with this management contract, and there's a lot of varieties of these management contracts, then it could be a security. And there's a ton of cases parsing whether this, you know, in some cases it was bundled in such a way that the individual condo owners didn't, you know, they didn't have any control over who rented the property. They didn't have any control over what the rental price was. They, you know, et cetera, et cetera. And in that case, it was an investment contract. They had other cases where, you know, the condo owner could make those key decisions about basically how this asset would earn revenue. And in those cases, they were not investment contracts. So it's going to depend on how your variable is set up, how that, you know, it's possible that the individuals have enough control, and it's possible that they don't.
Okay. So so going back to the case of like a simple object, like a handbag, I mean, the only thing that's going to happen is it's going to be stored and preserved. So is that, I guess, does that constitute exercising control?
If, you know, if that's being sold, if the fractional ownership of that handbag is being sold with the expectation that that handbag is going to appreciate in value, then it's probably a security. So,
Okay.
you know, if I had fractional ownership of a handbag, so like like what's that movie? The Traveling Pants, right? Where the four girls owned the same pair of jeans and they traded them and they all wore them, right?
Yeah.
You know, that was not an investment contract because they traded and wore those jeans. They weren't expecting them to appreciate in value. So they had no expectation of interest. So even though they owned them jointly, they had no expectation of profit. So it wasn't a security.
Interesting.
So traveling pants are not a security, but Birkin bag that you're keeping in a temperature controlled storage unit, probably a security.
Okay. Huh. All right. Fascinating. Thank you.
Thanks.
Going back on
I
mute.
can't believe we talked about rental pants, rental pools and traveling pants and Birkin bags, but let's see where this goes.
The law's amazing. I'm fascinated. Jim Lynch had a question. Jim, you want to clarify the question?
Yeah, thanks. And thanks, Jill, for coming. Really interesting. So my question is, totally hypothetical. Suppose you were building a like airdrop smart contract, they call it, where we would have like a sponsor come to our event, give some ETH into a pool, and then we just give it out to everyone. Like, is that legal? Should we be doing KYC verification and sending everyone 1099s at the end of the year?
Yeah, good question. Giving somebody ETH, probably not money transmission in the same way that, giving somebody on a street corner a $5 bill is not money transmission. Probably, again, are you taking it from one person and giving it to another? But if you just are giving away ETH, probably not money transmission. This is not legal advice. Should you do KYC? I would say on a risk basis, you probably don't need to do KYC, but I always encourage anybody involved in a cryptocurrency transaction to at least run this OFAC sanctions list, because the BSA only applies to financial institutions. So if you're not conducting money transmission, you don't have to comply with the BSA, but OFAC sanctions apply to everybody, whether or not you're a financial institution. And so, if you're trying to be cautious, better not to give ETH to somebody who's a terrorist. And the other thing that people don't know about OFAC is that it's strict liability. You don't go to jail with strict liability, but you can get some pretty hefty fines. So you don't have to know that that person is a terrorist. You only have to conduct a transaction with them, and you've broken, you're subject to administrative fines.
So how would one know someone's a terrorist? That's what I'm just saying.
Mhm.
I say terrorist because people know that's bad, but honestly, like a lot of the sanctions are not terrorism related.
So like what, what would be some other ones, like anything drug
So
trafficker?
you've got your location base. So you've got Cuba, Iran, Syria, Crimea. You've got kingpins. You've got people undermining the democracy of Cote d'Ivoire. You've got people undermining the democracy of Zimbabwe. So there's a full range of reasons that. So you've got, like I said, the territorial restrictions as well as specifically listed entities and individuals. And there's a lot of reasons, either political or terrorism. Narcotics kingpins, ironically, have the highest penalties because during when that was passed, war on drugs, we really, really hated narcotics kingpins. So even though we hate terrorists more than we ever hated narcotics kingpins, the anti-terrorism sanctions were promulgated under a different statute that has lower penalties. I don't know, trivia. Sanctions trivia.
So as long as you're a terrorist but you don't sell drugs, slightly less penalties.
Strangely enough, yeah, that there's not a lot of consistent logic to the sanctions regimes, in part because many of them are promulgated under different statutes. So there's not like one overarching sanction statute that they just add different regimes to. So many of them are promulgated under IEPA, the International Emergency Economic Powers Act, but a lot of them have specific statutes. So Iran has a specific statute, kingpins have a specific statute, and Cuba has specific statutes. So they're all different.
Interesting.
Again,
Mhm.
more OFAC trivia for, people who probably never
Yeah.
needed to know it, but I guess that's why we call it trivia.
That's awesome. So Peter asked 2 questions. Peter, do you want to ask them? Mr. Duhan. I'll ask it for him. So Bitcoin and Ethereum are not considered property by the SEC, or considered property by the SEC, not securities. What's the logic behind this?
Yes. No, that's a great question. To be perfectly honest, at the time they were issued, they probably were securities, or they were cryptocurrencies and the issuers were money transmitters. The pure truth is that they are so widely distributed, and the issuance of them is so far, the issuance and trading, like the whole ecosystem of Bitcoin and ETH are so attenuated from the initial issuance that that they're not securities. They may have been at one time, but by the time the SEC started paying attention, they weren't. The real interesting question, and I have a few theories, but there hasn't ever been a good definitive answer, is now that the SEC is paying attention, is there a path to get to where Bitcoin or Ethereum are? That's the real question for me, because the why is Bitcoin not a security? That's pretty straightforward. They just missed it, and when they caught up, it was too late. But what now? Like, again, how do you get from token offering to a non-security status? What's that path? What's that evolution look like? And Hester, what's her name, the SEC commissioner, did propose sort of a safe harbor that got a lot of attention, that would basically say, like, look, if you think that you're going to get to this level of distribution within 3 years, we'll give you a shot. Shoot your shot. You have 3 years to get there. So that it got a lot of attention. It didn't get much traction with the regulators. So we'll see if that gets reintroduced or modified or kicked around in some way. But that's the question, is how do you get there today?
Yeah, it's really interesting because there's a lot of innovation in the space, a lot of different chains. So if there isn't a path, it's great for Ethereum and Bitcoin, not so good for choice, right? If there is a path, still good for Ethereum and Bitcoin, but there's a door for everybody, I guess. Interesting. Alfredo Colon, do you want to ask a question, or I'll ask it for you? Alfredo. There. Going once, going twice. All right, Alfredo asks, I wanted to ask if it's a good idea to use blockchain to store individual criminal record history. Whoa, that way airports can consult blockchain before boarding the plane or even purchasing the ticket. Sounds like an Orwellian nightmare, but I'm not a lawyer, so what do you think?
Sorry, say that again. I was distracted by Phil's comment. I agree, Phil, that that's a potential path, but sorry, could you say that again?
Sorry. So basically storing individual criminal records on a blockchain. That way airports can consult the blockchain before anyone boards a plane or purchases a ticket. I'm not a lawyer, but it sounds a little invasive, but I don't know.
Yeah, I mean, this gets into a lot of areas, which honestly, I'm not super conversant. Also, it's going to depend on what your jurisdiction is. The US has way different laws around privacy of that kind of information than in the EU. In the EU, it'd be a non-starter under GDPR. It just it's a non-starter. But you know, to the extent that the information is publicly available anyway, I guess I'm a broken record. Putting on the blockchain won't change that. So but I don't actually know the extent to which criminal records are generally publicly available. So I guess the answer is I don't really know.
It works, yeah. Tommy, do you have a question? Would you like to ask the question? I'll ask it for you. Tommy, going once. Okay, I'll ask it. In regards to securities, what about the case of SAC3, tokenized bottles of sake? There's no advertisement of the value going up, but it's somewhere inherent in the auction model of selling tokens before the bottle is able to be claimed. He has no mic today. Oh, okay.
What packet? Oh, sake.
Yeah.
Tokenized bottles of sake.
It's like
Again, I think most of that centers on that expectation of profit prong. You know, if if a group of friends gets together to buy a really expensive bottle of booze because they want to drink it, fair enough. If a group of people, friends or not, get together to buy a really expensive bottle of booze because they're going to stash it and they think it'll go up in value, probably a security.
how does
Again, it's going to depend a lot on, for me, December was a really interesting month for me because we had the SEC no action letter from IMVU. And shortly thereafter, we had the Ripple complaint. And those two taken together, to me, are really illustrative of that expectation of profit prong. Because, one of my takeaways from the Ripple complaint is that their real failing was telling people that they think it's going to go up, so you should buy. Right, so they had a lot of public statements, they had a lot of official language, but privately in correspondence, their salespeople were saying, "Hey, this is going to go to the moon, baby. Buy in," right? And that created an expectation of profit. IMVU, on the other hand, is issuing a token that could very well go up. It will be tradable or is already tradable on a secondary market. But IMVU is saying that's not the purpose for which this is being issued. You should not expect it to go up. We're not going to list it on a secondary market. The intention and primary purpose of this token is to be used on the platform. And, if you as an individual choose to transfer it off the platform because you as an individual have decided that there may be some profit, that's up to you. And the SEC said, it's all good. And to me, the main difference there is whether the issuer is creating an expectation of profit. And I mean that not just in the words, but also in the deeds, right? Like IMVU has a platform where the tokens are usable. They're issuing them on platform. So they're not just saying there's no profit. They're saying, look, this is what we want you to use it for, but we're not going to stop you from trading it on the secondary market. Yeah, that's, if SOC3 is saying, look, groups of friends get together, buy this bottle of sake and enjoy it together, and they mean it and it's credible, it might be fine. But if they're just saying it and it's not credible, like if nobody really expects the sake to be delivered, if it's not really credible, then, that's a lot more risky.
Interesting. So, Wes Sapone, do you want to ask your question?
Sure. I had a couple questions early, like a couple weeks back about, if people are making NFTs on AirSwap and stuff like that, and taking pictures of celebrities, artists, stuff of that nature. So, if you take a picture of an artist and sell it, what kind of legal hurdles do you see there? I think that's the first question.
Yeah, I mean, you're gonna, it depends on the state, honestly, the rights, what rights you have to your own image and whether other people are allowed to monetize your image. I think, so if it's purely an image thing, like if you're taking a photograph of somebody in public, California and New York have pretty well developed laws around the rights to monetize image and restrictions around that, largely because they're big entertainment states, right? So that's a big deal in those states. So the rights to your image as an intellectual property law matter is slightly less developed than, say, copyright, or other creative intellectual property rights, but it's still a thing. And that's what I would make sure that you weren't getting cross-rise, with those laws, that that you were monetizing an image that you didn't have the rights to.
Right. And say you're obviously probably at a concert, right? Like, would there be anything that, the company that runs the concert,
Yeah, I'm gonna guess.
I feel like there would be
Usually,
more with them than the actual artist, right?
usually those ticket sales have like 10 pages of small print that basically say you can't do that. Um, so I'm gonna guess that, if you're at a concert and you take a photo of maybe anything, depending on what that small print says, you don't actually have the rights to monetize that. But that you would want to look at the small print when you bought the ticket.
Exactly. I think that's fair. Thank you.
Summation, look at the small print. The law covers everything you're doing.
Even though it's in small print, because nobody really wants you to look at it, that's the stuff you really should look at.
Yes, definitely. Nothing to see here, folks. Like, there's everything to see there. There's everything to see there. Oh my God, this has been amazing. I've learned a lot. Hopefully this has been instructive to everyone here. It kind of gives me some solace and some confidence that there are people who are thinking about this, and it's not just like this very opaque thing, and that there are laws that can be applied. Now, how they're applied, let's see, but at least there's some sort of precedent, and we're really excited. How do we contact you, Jill, if there is some people with funding that they want to get some legal work?
Sure. Yeah, no, that'd be great. I work at Gravis Law. I'm Jay. I can put it in the chat. I'm Jay Williamson at gravislaw.com. I'm in Seattle.
Beautiful city.
But I've got clients all over the country and all over the world. So I'm happy to work with, I work with all kinds of clients. I work with people who are building platforms, people that are issuing tokens. My pre-crypto background is, I worked in big law in DC for 10 years doing corporate compliance and white collar defense work. And then I went in-house. I was the deputy chief compliance officer at Cigna, responsible for their global anti-money laundering, sanctions, and anti-corruption compliance work, as well as their responding to government investigations and that sort of thing. So, kind of for corporate compliance work is my sweet spot. But the last 4 years, I've been doing a lot of crypto and blockchain work, which I love. It's really fun to work with people who have ideas. A company like Cigna needs legal advice. They're like, hey, we're thinking of changing the font on our policies from 11 to 12 point. It's just not that interesting, right? Like, there's not a ton of innovation or big ideas. And so, I really, really like doing this a lot more. I like working with people with ideas and, figuring out if there's a path, to bring their ideas forward and help them realize, what they're hoping to build. So yeah, I'm liking it a lot.
Extremely confident. Please reach out to Jill if you're looking for an amazing lawyer. It seems like you're an amazing lawyer. Get some funding, folks, and reach out to
Thank you,
Jill.
but it's nice to hear it from other people.
Yeah, it's great. You make it seem effortless. Jill, thank you so much. We really appreciate your time, and hopefully we can speak to you again. Thank you so much.
Awesome.
Thank you, everybody.
Thanks, guys.
Thanks.
Thanks for inviting me.
Thank you, guys.
Thank you, Jill. It was great to see you today.
Thank you, Jill.
Thank you.
Thanks, Jill. Great
Thanks.
message.
Thank you.
Thanks, that was great.
Bye. See you guys.
Thank you.
Awesome. See ya.